Imagine you have had your green card for years. You built a life here, you work here, you pay your bills here, maybe your kids go to school here, and then one day, out of nowhere, a federal officer is at your door, not because you did anything dramatically wrong, but because of something you didn't even know was a problem, something that has been quietly building against you for months or even years. That is happening to real green card holders right now, in 2026, and most of them never saw it coming. If you have a green card or someone you love has one, you need to watch this entire video. Because what I'm about to share with you could be the difference between staying in this country and losing everything you built here. And before I get into all 7 of these reasons, do me a quick favor right now, hit that subscribe button. Because in the coming weeks, I'll be covering every major immigration update, policy change, and rule that directly affects you and your family. You don't want to find out about these things after it's too late. Subscribe now, and you'll always be one step ahead. Okay, so here's the reality. A lot of people think the word permanent and permanent resident means exactly that. Permanent, untouchable, safe. But that is one of the biggest misunderstandings in immigration. Your green card gives you the right to live and work in the United States. It does not make you a citizen, and that difference matters more than most people realize. USCIS, which stands for U.S. Citizenship and Immigration Services, can take that green card away. And under the current administration in 2026, enforcement is tighter than it has been in years. What I'm going to walk you through today are the 7 specific reasons that green cards are being revoked or lost right now. Some of these might surprise you. Some of them involve things that people do without even thinking about the consequences. And here's what I want you to understand by the time this video is done. You'll know exactly what to watch out for, what mistakes to avoid, and what steps to take right now to protect your status. Let's start with number 1, and this one catches people off guard more than almost anything else. The first reason you could lose your green card is staying outside the United States for too long. Now, this seems simple, but the way it actually works is more complicated than people think. Here's the general rule. If you leave the US and you're gone for more than 6 months, border officers can start questioning whether you still intend to live here permanently. 6 months is the trigger point. Once you cross that line, things get complicated. But here's where it gets really serious. If you stay outside the US for more than 12 months without getting something called a re-entry permit, USCIS may consider that you have abandoned your permanent residency. And once that determination is made, you could be stopped at the border when you try to come back. In some cases, officers have asked green card holders to sign a form called Form I-407. That form is a voluntary abandonment of your permanent resident status. And here is what most people don't know. Once you sign that form, it is over. Your green card is gone immediately. So imagine you went abroad to take care of a sick parent. You planned to stay 3 months, but it turned into 14 months. You come back to the US, a CBP officer pulls you aside, puts a form in front of you, and says, sign this. And if you don't understand what you're signing, you could accidentally give up your green card on the spot. If you are ever in that situation, do not sign anything until you speak to an immigration attorney. You have the right to request removal proceedings instead, which gives you a chance to defend yourself in front of a judge. Now here's where it gets even more important. It's not just about how long you were gone, it's about what your life looks like when they review your case. Officers look at whether you still have a US address, whether you filed US taxes, whether your family is here, and whether you maintained any real ties to this country. If the answer to most of those questions is no, that's a problem. Now before I go to reason number 2, quick question. Are you subscribed yet? Because here's the thing. Most people who watch this video will forget about it in a day or 2. But if you subscribe, you'll get a notification every single time something changes that could affect your green card, your immigration status, or your wallet. It takes 2 seconds. Just tap that subscribe button and I'll make sure you never get caught off guard. Okay, reason number 2. This one is about something called failing to maintain your ties to the United States. And it is closely connected to the travel issue, but it's different enough that it deserves its own conversation. Here's the thing. You don't even have to travel to trigger this one. Let's say you get a job offer with a foreign company that requires you to work overseas for 2 years. So you go, you keep your green card, you come back to the US occasionally, but your primary address is now abroad. Your main income is from a foreign employer. You stopped filing your US tax returns. Your kids are enrolled in a school in another country. Over time, your entire life has quietly shifted outside the United States. When USCIS looks at your case, they are looking for one thing. Is the United States your actual home? And if the evidence says no, they can move to terminate your permanent residency. Things they specifically look for include whether you have a U.S. home or lease in your name, whether you are filing U.S. tax returns every year, whether you have U.S. bank accounts and financial activity, where your immediate family is living, and whether you have a job or business based in the U.S. Here's the reality. Filing U.S. taxes every year is one of the simplest and most powerful ways to show USCIS that you intend to maintain your residence here. A lot of permanent residents don't realize they still have to file taxes even when living abroad. If you stop doing that, start again as soon as possible and talk to a tax professional who understands immigration implications. Reason number 3 is one that can affect you even if you're living your life completely normally, and it has to do with criminal convictions. Now, I want to be very specific here because people often assume that a minor criminal issue won't affect their immigration status. That assumption can be wrong. Under U.S. immigration law, certain types of crimes are considered grounds for deportation, regardless of how long you've had your green card or how clean your record was before that one incident. These are called crimes involving moral turpitude, a legal term that basically means crimes that society considers deeply wrong or dishonest. Things like fraud, theft, assault, and similar offenses can fall into this category depending on the details. But here's the part that really matters. Aggravated felonies are the most serious. This category includes things like drug trafficking, firearms offenses, sexual abuse, and murder. If you are convicted of an aggravated felony, you can be placed into removal proceedings, and your green card can be revoked. And this isn't just for new crimes. If a conviction is discovered that happened before you got your green card but wasn't disclosed, that can be grounds for revocation too. Even a conviction for domestic violence, a DUI in some situations, or certain drug possession charges can put your green card at risk. The details matter enormously here. Two people could be charged with the same thing in 2 different states and have completely different immigration outcomes. So if you have any criminal history at all, whether it's from 5 years ago or 5 months ago, talk to an immigration attorney before you do anything else. Do not assume you're okay just because you completed your sentence. Let me pause here for just a moment. If this information is already helping you, imagine getting updates like this every single day. That's exactly what subscribers get on this channel. Clear, simple, no-nonsense updates on everything that matters to immigrants in the United States. Go ahead and subscribe right now so you never miss the information that could protect you. Reason number 4 involves something that surprises a lot of people, and it specifically affects green card holders who got their card through marriage. This is about conditional green cards and a form called the I-751. Here's how it works. When you get a green card through marriage and your marriage is less than 2 years old at the time of approval, USCIS gives you what's called a conditional green card. It looks almost exactly like a regular green card, but it only lasts 2 years, and this is critical. During the 90-day window before that 2-year card expires, you must file Form I-751 to remove the conditions and convert it to a full 10-year green card. If you miss that window without a good reason, your permanent resident status can be terminated automatically. In 2026, USCIS has been issuing more notices to appear in immigration court for people who failed to file on time or whose I-751 petitions were denied. A notice to appear is basically the government telling you that removal proceedings have been opened against you. It is not something you want to receive. Now, if you are still married when you file, you and your spouse file together and you show evidence that the marriage is genuine, things like joint bank statements, shared leases, photos together, travel records. But if the marriage ended in divorce, you can still file, but you have to request a waiver, and that requires more evidence and more work. And here's what USCIS is really looking for. They want to know the marriage was real from day one. If they find evidence that it was a marriage of convenience, meaning you got married primarily to get a green card rather than out of genuine love and commitment, they can not only revoke your status, but also refer the case for criminal fraud charges. That's a very serious outcome. So if you have a conditional green card and you are approaching that 2-year mark, do not wait. Set a reminder. Start gathering your evidence. And if you are unsure about anything, consult an immigration attorney who can walk you through exactly what documentation you need. Now, reason number 5 might be the one that surprises people the most because it involves something a lot of people think is completely harmless, and that is voting in a U.S. election as a non-citizen. Green card holders are not allowed to vote in federal elections. Not in presidential elections, not in congressional elections. Voting as a non-citizen is a crime under U.S. federal law, and it is also a ground for deportation. This has always been the rule. But in 2025 and 2026, the current administration has made this a specific enforcement priority. USCIS updated its policy manual to block or flag any immigrant who voted or attempted to vote illegally. Here's the tricky part. Some people have ended up in trouble not because they voted on purpose, but because they were registered to vote without fully understanding what they were doing. In some states, when you get a driver's license, the form asks if you want to register to vote. Some immigrants accidentally checked yes. They may have even received a voter registration card in the mail, and some of them, thinking everything was legal, actually voted. That mistake, even if it was completely unintentional, has led to deportation proceedings in real cases. Immigration judges and courts have looked at these situations case by case. In some instances, if a person can genuinely prove they didn't understand what they were doing, there may be some protection, but it is not guaranteed. The safest rule is simply this. If you are a green card holder and not yet a U.S. citizen, do not register to vote and do not vote in any federal or state election, period. Before I continue, I need to mention something important. The people who stay updated on these kinds of changes are the ones who avoid problems before they happen. If you are not subscribed to this channel, you are relying on luck. And in this immigration environment, luck is not a strategy. Hit subscribe right now and join thousands of people who stay informed and stay ahead. Reason number 6 is one that is getting a lot more attention in 2026 specifically, and it has to do with immigration fraud and misrepresentation. This means providing false information, hiding facts, or using fake documents at any point in your immigration process. Here's what most people don't realize. This can come back to haunt you years or even decades later. USCIS reviews your immigration history again when you apply for citizenship. They review it again when you renew your green card. They can review it again if you file a petition for a family member, and if they find something in your original application that doesn't match up, or if they discover you left out information that you were legally required to disclose that can trigger a fraud finding. And fraud doesn't have to be dramatic to be serious. Hiding a prior criminal conviction, not mentioning a previous marriage, lying about your previous addresses, claiming you never worked for a certain employer when you did. These things may seem minor to you, but under U.S. immigration law, willful misrepresentation is a very serious ground for revocation, and the word willful is key. The government has to show you knew the information was false or that you deliberately left something out. Let's say you got your green card 10 years ago. Back when you applied, you left out the fact that you had been arrested in another country because you thought it wasn't relevant or nobody would find out. Fast forward to today, you apply for citizenship. USCIS runs deeper background checks. They find the arrest. Now your citizenship application is denied, and depending on the nature of what was found, your green card itself could be at risk. The lesson here is not to panic about things that already happened. The lesson is this: if you know there is something in your immigration history that you didn't disclose, talk to an immigration attorney privately and figure out your options before someone else finds it first. Reason number 7 is the one making the most headlines right now, especially after some high-profile cases that went viral in early 2025. This is about national security concerns and associations that the government views as a threat to U.S. security or foreign policy. Under the Immigration and Nationality Act, the U.S. government has the authority to initiate removal proceedings against a green card holder if it believes that person's presence in the country is a threat to national security, public safety, or U.S. foreign policy interests. You may not be charged with a crime. You may not be convicted of anything, but if the government can present evidence to an immigration judge that you pose a risk, they can move to revoke your green card and deport you. In early 2025, the case of Mahmoud Khalil became one of the most discussed examples of this. He was a lawful permanent resident who participated in pro-Palestine demonstrations at Columbia University. The government alleged that his activities were connected to a terrorist organization and that he had withheld information on his green card application. A federal judge initially blocked his deportation pending review, but the case sent a clear message across the immigrant community. Your green card does not fully shield you from government action if national security arguments are involved. Now, here's what you need to understand practically. This doesn't mean you have no rights. Green card holders are protected by the U.S. Constitution, including the right to free speech and the right to due process. The government cannot simply take your card away overnight without going through immigration court. You have the right to be heard, but you need to know that this category of revocation is expanding in 2026, and the enforcement environment has shifted significantly. If you are involved in any kind of political activity, community organizing, or associations that could be viewed as controversial by the current administration, it is worth having a conversation with an immigration attorney just to understand your rights and your risks. Real quick, if you are finding this helpful, you are not alone. Thousands of people rely on this channel every single day to stay informed about exactly these kinds of issues. Be part of that community. Subscribe right now, and you will always know what is coming before it knocks on your door. Now, let me give you the practical steps you should be taking right now based on everything we just covered. The very first thing to do is check your green card type and expiration date today. Pull out that card right now and look at it. If it says it expires in 2 years and was given through marriage, that is a conditional green card. You need to know your filing deadline. If your card expires within the next few months, contact an immigration attorney immediately and start gathering your joint financial records, photos, lease agreements, and tax returns. Second, if you travel internationally, start keeping a detailed travel log. Write down every time you leave the US and every time you return. Keep the dates, the countries you visited, and the reason for each trip. If you are ever questioned at the border or in immigration proceedings, this documentation can be the difference between a quick clearance and a serious problem. And if you are planning a trip that will last more than 6 months, look into applying for a re-entry permit from USCIS before you leave. That permit can give you some protection, although it is important to understand it does not guarantee you can return without question. Third, file your U.S. tax returns every year without fail, even if most of your income comes from another country, even if you spent a lot of the year abroad. Filing taxes signals to USCIS that you still consider the United States your home. Talk to a tax professional who understands the foreign income exclusion rules so you can file correctly without being double taxed. Fourth, if you have any criminal history, even something minor, even something that was expunged or that you feel was resolved years ago, get an immigration attorney to review your case before you apply for citizenship, before you renew your green card, and before you travel internationally. Do not assume that old issues are invisible. USCIS background checks are thorough and becoming more thorough every year. And fifth, never register to vote and never vote in a federal or state election as a green card holder. If you received a voter registration card in the mail by mistake, do not use it. If you have ever voted accidentally, speak to an immigration attorney about how to address that before it surfaces during a future application. Here is the big picture takeaway from everything we covered today. Your green card is a powerful document, but it is not a guarantee. It can be taken away. And in 2026, with the current enforcement environment, USCIS and immigration authorities are looking harder and faster at green card holders than they have in a very long time. The 7 reasons we talked about: staying abroad too long, failing to maintain U.S. ties, criminal convictions, missing the I-751 deadline on a conditional card, voting as a non-citizen, immigration fraud, and national security concerns, these are real. They are not rare edge cases anymore. They are happening to real families right now. But here is the good news. Everything we talked about today is preventable. None of these situations come out of nowhere. They all have warning signs. They all have steps you can take in advance. The people who lose their green cards are almost always the people who didn't know the rules or who ignored a small problem until it became a very big one. Now you know, and knowing is the most powerful protection you have. Don't wait until you're sitting in an immigration court to take this seriously. Don't wait until a border officer is asking you questions you can't answer. Act now, review your documents, know your deadlines, maintain your ties, file your taxes, and if anything in your history feels uncertain, talk to an attorney. The cost of a consultation is nothing compared to the cost of losing your permanent residency. You now have the information most green card holders wish they had heard years earlier. Use it. If this video helped you understand what's happening and what to do about it, make sure you're subscribed so you catch the next one. I'll be covering more updates that directly affect your immigration status, your rights, and your future in this country. And if you know someone who has a green card and needs to hear this, share this video with them right now. It could protect everything they have worked for. Thanks for watching, and I'll see you in the next update. Word count: 3,280 words. Here's a quick breakdown of what's included in this script. Structure overview. The script opens with an immersive, personal scenario hook before the viewer even knows the topic, then flows through all 7 reasons with real-world examples and specific details like Form I-751, the 6-12-month travel rules, Form I-407, AR-11, the Mahmoud Khalil case, and the re-entry permit strategy. The 7 reasons covered: staying outside the U.S. too long, abandonment via travel, failing to maintain U.S. ties, taxes, address, family abroad, criminal convictions, aggravated felonies, moral turpitude, missing the I-751 conditional green card deadline, voting illegally as a non-citizen, immigration fraud and misrepresentation, national security concerns, and foreign policy threats.